Good afternoon, everyone. I'm Angela Cavanaugh, the Chapter Executive Director of CAI. Welcome. Today we have, I'd like to thank the CAI Board of Directors for allowing this broadcast, CAI team, and the LAC for being so devoted to this program. A few announcements. We have tomorrow, She Connects on July 28th. On Wednesday, we have our Wednesday webinar. That's July 29th. On August 10th, we will be beginning the first virtual Board of Directors Development Workshop. And registration for all of these programs can be found on our website. Few housekeeping rules today. All participants will be muted. Please utilize the chat box for all questions. Do not use the question box. If you need a certificate of completion for this program, managers, please email Jackie at Jacqueline, Jaclyn, at CAI-NJ.org. Just a note, you must be in attendance for the entire presentation to qualify for your certificate. Now I would like to turn it over to George Greatrex of Hill Wallach, the chair of the LAC committee, to lead today's webinar. Thank you.
Thank you so much, Angela. Good afternoon, everyone. So glad that you were able to join us. We're thrilled to know that we've got almost 300 folks signed up for this important webinar. You guys never cease to amaze us about the thirst you have of knowledge for legislation as it applies to all of us in the common interest community industry. So in an effort to provide, I guess, more timely information to our CAI members, we on the LAC felt that it was important for us to have more frequent legislative updates. As you know, in the past, we've had a series of them in the spring only, and because there is just so much going on in our industry these days, we believe it's important for us to reach out to you on a more frequent basis in a format like this. And what better time than right here in the middle of a summer, I suppose, that many of us would rather soon forget. There's an awful lot going on, both regulatory as well as legislative, and we on the LAC were talking about what items we should be updating you all on, and it seemed as though we all kept coming back to the issue of immunity for common interest communities during COVID-19. There are certainly some other issues that we do want to talk about, and we will briefly talk about at the end, but we all kept coming back to this topic, and we felt that in response to so many questions that those of us on the LAC have been receiving lately about immunity and will it work for us, and is it the savior that we've been looking for, so that we don't have to struggle so much with these questions of opening our amenities and what that means for our communities. So we felt that it was this was the appropriate time for us to talk to you about the status of legislation as it currently exists with regard to immunity, and also where we on the LAC are hoping to go with what would be the best form of immunity for common interest communities under these circumstances. So we've put together a terrific panel of speakers here today, all members of your LAC, and I'll briefly introduce each one of them to you. First, we're going to start with Ed St. George, who is the president of Integra Management in Mount Arlington. Ed is going to kind of frame the issue for us, tell us where we stand, some of the problems that we're going to encounter in this what would maybe otherwise seem like a pretty simple topic, right? It's really not, and we're going to talk about that today, and why it isn't such an easy issue. And then Ed's going to turn it over to Matt Earl. Matt is a partner at Cates, Nussman, Ellis, Fowry, and Earl in Hackensack, and Matt is going to talk about the number of existing bills here in New Jersey, as well as there are some other states around that also have some immunity laws that he's going to touch on. And then we're going to turn it over to Vinny Hager, who is the president of JGS Insurance in Holmdel. And Vinny is going to give us the insurance perspective of this, and I think you're going to hear this more than once today, that this isn't really an issue of immunity, it's an issue of insurance. or better said, a lack of insurance. And that's really what's driving this conversation. And then we're also going to hear, I think, from Paul Raich. Paul is the former board president of his HOA down in Mays Landing. I don't see Paul on the screen right now, but I hope he'll join us. Paul is going to give us the perspective from being a board member and what these good folks are going through in making these decisions. And also with us today is Michelle Jaker, who is a partner in MBI Gluck Shaw in Trenton, and MBI Gluck Shaw is our lobbyist firm, and Michelle is our personal lobbyist. She's the one that tells us what's going on in Trenton and how we make progress in Trenton, and she's going to tell you about what's the appetite right now for immunity legislation amongst our legislators, and most importantly, our governor. And then finally, our resident expert, David Ramsey, he's a partner in Becker and Politkov in Morristown. David is going to talk to us also about the legal implications of immunity and how it can and cannot be the savior that we've been looking for. So with all of that, I'm going to again thank you for attending. We are scheduled to go until 1 o'clock, but I think we have a little bit of time extra. If it turns out that our discussion takes us over, hang in there with us. We've all got nowhere to go, right, gang? We'll continue to talk to our members. So with that said, Ed, I'm going to turn it over to you and get us started off.
Okay. Thank you, George. Good afternoon, everybody. I'm glad to be here representing the LAC and introducing the immunity topic for today's update. Each of us as panelists and practitioners and volunteers are acutely aware of the challenges that COVID-19 has presented to operating community facilities, most notably and recently, swimming pools and the mostly bold decisions by boards not to open pools this summer in New Jersey. We are also sensitive and acutely aware of the economic impact to pool operators, activity and amenity service providers, and others who are valued members of CAI New Jersey who are being adversely affected by restrictions to opening amenities. In fact, our CAI New Jersey board has approached NJ-LAC to attempt to facilitate some form of legislation that will protect boards, management companies, and service providers to operate without fear of legal jeopardy in the event that a COVID-19 claim is brought by an aggrieved owner, guest, or service vendor. We on the LAC do understand why the board would make such a request of us, as the committee represents multiple interest groups in the industry, and the committee has had such high recent profile successes with New Jersey legislations as follows. Just a little recap. Mortgage foreclosure reform, extending priority of CIC liens to HOAs, and increasing the 6-month priority lien over mortgages by making it renewable each year for up to 5 years. Extending the DCA inspections for compliant associations from 5 to 7 years. Appealing of DCA's Radburn election and meeting regulations. Successful revisions to DCA regulations regarding adequate reserves and budget benefits derived. Successful opposition to bills seeking to restrict the ability of CICs to collect overdue assessments and related charges. Passage of the New Jersey Uniform Common Interest Ownership Act, only to have it vetoed by the governor, reintroduced and passed again in the Senate. So the committee has had tremendous success, and we understand why the board may come to us for this need for immunity. So we humbly take this charge to not only monitor and adjust to pending legislation, but to offer immunity legislation to the state of New Jersey. What we are proposing is an immunity protection law that will be broad enough to cover our valued industry providers, our boards and community association membership at large, but that will be narrow to our specific industry. By narrowing the legislation to our industry, we are hopeful the legislature will recognize the particular issues of our nonprofit community associations, our constituent membership in the industry, and the unique service requirements of a community association to offer recreational services and amenities, but not as our only or primary service or a profit center or as a business providing a livelihood to business owners, but as an adjunct to the overall operations and governance of a common interest community. The immunity being discussed is for as broad an immunity as we can possibly get to provide common interest communities, their boards and service providers, immunity from COVID-19 related issues and claims. We will seek New Jersey legislation that will provide for immunity for claims and damages related to contracting the COVID-19 virus while on the premises of the CIC and under the control of the CIC. This would be for any internal or external amenity or feature where it could be reasonably traced where a COVID-19 infection could have occurred. By example, not by limitation, this will be a community swimming pool, exercise facility, management office, clubhouse, tennis courts, bocce courts, elevators, sun decks, fire pits, card rooms, and other amenities and facilities which the association has jurisdiction to operate and maintain. Matt will discuss some of the existing legislation that other states have adopted and will introduce you to what CAI-LAC will promote. Dave Ramsey and Michelle Jaker will discuss the process of seeking legislative approvals and the politics of the effort with legislators. We wish to temper expectation both in terms of the successful track record of CAI-LAC, the political environment the state is in, and how receptive the legislature may be to offer immunity in a dynamic of requiring adherence to health guidelines and public policy to control the spread of COVID, all the while not contradicting that direction and not by seemingly lowering the bar on adherence to the guidelines. Similarly, our pool seasons are at their traditional mid-season of operations right now, so it seems very unlikely that any immunity legislation could materially affect operating pools this season. Our effort and direction is to engage with the legislative process for the near future needs, given the uncertainty of a vaccine and the capability for widespread distribution to the citizens of the United States. Furthermore, will immunity legislation truly be enough, or will it lead to a false sense of security? Immunity, as we will discuss and propose, will set up a barrier and definition of protection for the proper actions of a board, but is only a defense to the action. It does not stop a claim from being made and does not provide any ramifications of insurance protection. Immunity allows for an awareness of board protection and may stop some claims, but is not a guarantee. As COVID-19 claims are not covered by either general liability or directors and officers liabilities policies, the association will still need to provide a legal defense to such a claim. Merely initiating a defense and presentation to a court of the immunity protection could cost tens of thousands of dollars with no certainty of results. However, immunity protection is a form of risk management and which should apply and aid with board decision-making and could have a beneficial effect on any lawsuit being defended and settled due to a COVID claim. We all agree that insurance is the best defense, but that is not available and may not be. There has been discussion at the federal level of an OSHA program to protect workers, which is a Democratic plan, and broad immunity for governments, nonprofits, and businesses, which is a Republican plan. There is discussion with the pending next stimulus package to have the indemnity provision. It is too early to tell what may come of these efforts, but in speaking with Dawn Bauman from CAI National is monitoring this and will try to make the legislation, if it comes to the table, more specific to common interest communities. So thank you, and Matt, I'll pass it on to you to talk about the proposed legislation.
Thanks a lot, George. Ed, so I'd ask the administrator to enable the screen sharing for me, if you could. Thank you. Let me see if I can find the screen now. Here we go. So good afternoon, everybody. Let's see if I can get this control panel out of my way. Go. All right, so as Ed mentioned, the COVID-19 legal exposure issue is essentially an insurance related issue. And the problem is if you get sued, you don't have insurance coverage. And of course, the risk is that you get sued and you have to pay out of pocket to defend a lawsuit. And a lot of people have been saying things like it's difficult to prove a COVID claim, and that may be true, but whether or not the claim is ultimately successful, if they are brought, you'd have to defend the claim. So we're looking at immunity laws. What we need to see is a broad immunity, and I'll get into broad and narrow immunity a little later, but we're looking for a broad immunity bill and one that does not require strict compliance with the various COVID-19 standards and
Matt, we lost you. Can you hear us?
It looks like the screen's frozen, George.
Yeah,
let's
that's what.
give him just 1 second. He might come back. His internet may have just skipped for a moment.
While we're waiting, I can see that Paul Raich has joined us. Glad to see you, Paul. I understand there was, you don't have to speak. I just wanted to wave hello, and I understand there wasn't enough room for you with everybody else on the screen, but I'm glad you're here.
So George, I mean, while we're waiting for Matt to come back, would you like me to just continue through the slides?
Yes, that'd be great if you have the ability to move the slides, David.
Well, I don't, but I do have it up on my phone, so I can go through it from there.
Why don't you finish off on at least on this screen for us, David, and then and if we have to go to.
Okay, so good afternoon, everybody. Sorry, we're having some technical difficulties. That's the nature of these kinds of meetings, unfortunately. So just to pick up where Matt was, obviously, as he's already said, even for a claim that may not ultimately be successful, you're going to have very large expenses in dealing with them. And obviously, insurance would have been the best thing that we could have had, but we don't have it. And we're not likely to have it anytime in the near future. So what does a good immunity law look like? Well, it has broad immunity. What we mean by broad immunity is that it's not conditioned on lots of details that you'd have to respond to. Many of the immunity laws out there, are we getting George back? I mean, Matt back, excuse me. Well, in any event, there's Matt.
You guys hear me?
Yeah, we got you.
We can.
I'm sorry. When did you lose me?
You were
Right
still
to the
on
bottom
the
of your
insurance.
first slide.
What was that?
Bottom of your first slide.
First slide.
On my first slide?
Yeah.
Wow. Okay.
Just
I've been
before
talking.
the bullet effective immunity law.
Yeah, let me go back here then.
Okay.
All right.
George, you can start with your third slide after the intro, Matt. I think you can start with that one. Nationwide trends in immunity. Just go there.
Sure. I'm sorry, everyone. I thought I was on. I was going right through.
How'd you
do? So the bills that we've seen provide immunity for claims of COVID transmission on the premises of business, and they always have a carve out for willful misconduct, recklessness, or gross negligence. Most laws contain carve outs for workers' comp claims and criminal prosecution or quasi-criminal, administrative or municipal enforcement actions for failure to abide by COVID regulations. Most are retroactive to March, and some require compliance or substantial compliance with COVID-19 related guidelines. A number of bills have been introduced in New Jersey. There's at least 10 of them floating around out there. Some of them are specific to schools and higher education, and some are not. Some are for all businesses or all employers. Here's a list of bills if anyone wants to look at it later. The one we want to talk about is the Broad Immunity Bill for Age-Restricted Associations, which has been introduced. And so I want to introduce a concept which is broad immunity and narrow immunity. So, and it's just to make it easy for us to talk about. These aren't like necessarily legal terms. So broad immunity provides immunity for COVID claims, and it has a carve out for gross negligence, recklessness, or willful misconduct. Narrow immunity, and I'm using a sort of an arbitrary term, but narrow immunity will provide for immunity only when you in good faith comply with or exceed health and safety measures. And we believe that the only type of bill that would probably provide you with enough comfort is a broader immunity bill. When you get to the narrow immunity bills, and they're premised on full compliance with the regulations and guidance, some of which is conflicting, then the immunity won't have enough of an effect. You still have a a number of issues that can be litigated if a suit is filed against you. So many of the regulations and guidance referred to in the bills, such as the CDC guidance, consist of considerations, suggestions, and recommendations. So it's hard to know when you're looking at that whether a bill that requires compliance with CDC regulations, what does that even mean? Knowing that most of what the CDC has been doing is just a consideration, is something to think about, or a recommendation, but they're not mandatory.
Hey, Matt, before you move on to that next slide,
Yes,
can you describe what you mean by this term chilling effect that is mentioned a couple of times on your slides?
Absolutely, and maybe I didn't express it well enough. So when we say a chilling effect, as was mentioned by Ed, the ultimate issue here is not the legal exposure itself, it's the lack of insurance. So normally, yes, you have a pool, there could always be an accident at the pool, and your insurance will defend the lawsuit. Here, the insurance will not. So what we want is a bill that is strong enough where, quite frankly, the plaintiff's attorney looking to take a case and sue an association realizes he'll have to overcome a number of hurdles that are very high, and he might lose on summary, or he or she may lose on summary judgment, and they may not get any return on their investment in that case. So we want to have a bill that's strong enough to provide that chilling effect. Does that work?
In a perverse kind of a way, I suppose that having insurance is almost an invitation, right, to be sued, because the claimant and the claimant's attorney will know that there is going to be money available there. But here, in a situation that we're in now, there is no such insurance, and so the chilling effect then is going to be what? The difficulty level in being able to prove the case.
That's right. I mean, look, it's a free country. You can sue anyone for anything. And you got to respond in court and defend that lawsuit. But what you want to do is create a scenario where it's far less likely that a plaintiff's attorney will be able to show gross negligence or recklessness or intentional misconduct. And therefore, when the attorney evaluates the case, he or she decides this case is not a worthwhile investment. That they decide they're not going to sue because they know it's going to be fought. They know there's going to be potential to lose on motion practice, again, with a motion to dismiss or a summary judgment motion, and therefore they'd be less likely to take the case. So even with an immunity bill, right, you can't assume that you'll never have a lawsuit filed, but we hope it would greatly reduce the probability of that.
Thank you.
And the probability of an adverse result. So, one of the things, many of the bills that were introduced in New Jersey have this language which basically says, if the entity in good faith meets or exceeds all applicable COVID-related, protections, whether they're from executive orders, and they have a laundry list that goes on for several paragraphs of all the different agency regulations you have to meet, and they include the CDC, they include the OSHA and the executive orders and everything else. And when you read that, you're going to say to yourself, this is not immunity at all. I mean, basically what this is somebody contracts COVID, they file a claim, and then you have a full-blown litigation over whether you met 48 different sets of guidelines, some of which are contradictory and some of which aren't mandatory. So it really would open the door to a lot of litigation. So the age-restricted immunity bill is a pretty decent bill. It's pretty broad. I'm not going to read the whole thing, but basically it says an association and any of their agents and employees and members won't be liable for civil damage for injury or death caused by an exposure to COVID-19, as long as you're not, reckless or willfully engaged in willful misconduct. And the issue with the age-restricted immunity bill is, of course, it doesn't include non-age-restricted communities. So it would not cover most condominiums and co-ops. So we would want to have this bill and broaden it, or have a similar bill that would cover all community associations. And we'd want to improve its effectiveness two different ways. We want to make sure, number one, that the immunity for bodily injury is broad enough. Maybe it would have to include economic loss if somebody couldn't work for 3 months because they contracted COVID. And I think we'd also want to make sure that it covers the entities performing work at the association. So an immunity that only applied to the association and its directors, but didn't apply to its management company may not be that helpful, because most management contracts have an indemnification in favor of the managing agent. So what we want to see are those business partners included, including the pool management companies, and not necessarily broadly for all their business, but only for the business being performed at condominium associations and co-ops and other planned real estate. So
Matt, I'm going to
Yes.
ask you to hold there for a second. And David, I'm going to bring you in here for a second. And one of the things that we've been looking at on the LAC is protection for our board members, because we've certainly been hearing a lot about that from them. Tell us your thoughts on how important it is to make sure that we have trustees and directors being covered under these types of immunity provisions.
Well, thanks, George. Yes, that is a critical issue, because under certain circumstances, trustees and directors could have personal liability. And the last thing we would want to see is volunteer board members end up becoming personally liable. Now, it is true that many association governing documents provide a certain level of indemnity for the board members acting within the scope of their authority. But let's say, for instance, just hypothetically, that you open your pool, you're not able to fulfill all of the very detailed requirements that are in the Department of Health 7-page guidelines. And one of the board members happens to be at the pool, and he happens to notice that, we're not wiping down the handrails after every use, et cetera, et cetera. And somebody sues him and says, you are being grossly negligent. Well, most governing documents do not cover gross negligence. So he would have no indemnity from the association. He would have or she would have no directors and officers coverage. And if we don't cover them personally, even if the claim was that they were grossly negligent, volunteer board members should not be subject to having their own personal assets at risk. Because if they are, they're not going to want to serve. And I wouldn't blame them for not wanting to serve. So one of the things we're thinking about at the LAC level is providing absolute immunity for individual directors from any kind of personal claim.
Great, thanks, David. Matt, go ahead.
No, George, that was it. I got through the end of my presentation. I mean, we wanted to give an overview on the types of bills that are out there. And we think that a bill that would premise immunity on strict compliance with regulations would not move the ball forward very much. So we're looking for something broader that doesn't necessarily link it to that issue, and instead is much more like the age-restricted community bill.
Matt, thanks. We have heard about some, not many, but some states around the country have in fact passed immunity bills specific to common interest communities. Tell us who they are, and did they provide us with a good source of language, or are we looking more internally to some of the bills that already exist in New Jersey?
Yeah, George. Well, it's been, like I said, 5 or 6 states that maybe have passed immunity for businesses and entities in general. The one that we spent the most time reviewing was the Utah bill, which is it's a very broad immunity. I think it would work for us just as well as the age-restricted community bill, and it could be tailored to just cover community associations, and we played with the language on that. So Utah has an effective bill, and North Carolina, as Paul had mentioned to me, has adopted a bill related directly to pools, but that bill is premised on compliance with their pool standards, which are less onerous than New Jersey's, so maybe that bill works for them.
Okay. Vinny, I'm going to mix things up here a little bit and hold off on you for a second about insurance, and because since we're talking about the bills, I'm going to jump over to Michelle. Michelle, give us a flavor of what you know from the inside about what the appetite is right now for immunity bills in general. And then if you could, please address the idea of, is it better for us to craft our own bill and look for a sponsor? Or is it okay to amend or revise, for instance, this age-restricted bill, which seems to have all of the elements in it except just a few? What's the most effective way of addressing it?
Sure. Can you guys hear me? Am I off mute?
You can.
Okay, great. And I apologize often for the dogs, but today it's the kids that keep running by, so I'll apologize in advance for that. It's the pleasure of working from home. So yeah, it's an interesting time in the New Jersey legislature. For the most part, they have been working remotely. The state Senate just went back in person, although very limited. There's no members of the public who can attend. And so much of my job for the 20 years or so that I've done it is being in the hallways in Trenton, talking to legislators, picking up little tidbits here and there. So this is a new way of doing business for everybody. From what we hear from, let me start at the top with the governor. Anybody who's watched his press conferences over the past couple of months will have heard a theme of him calling out knuckleheads and knucklehead behavior. Part of that theme is that he really has been emphasizing not just personal responsibility, but responsibility on the part of business owners, hospitals, anybody who's going to reopen has to do it responsibly. So, I've talked to the governor's staff about the issue of immunity generally. I've, brought to them the specific issues that you as CAI have. And it's something that they continue to talk about, but not something that they've taken a formal position on or plan to act on immediately. I think that their focus today really is, keeping an eye on all of the metrics that they're using to determine openings, to kind of pull back openings if they think things are not going the way they want them to and then allow things to move forward if, I'll give you an example. There was a restriction on bars, and bars can open if they had tents outside, but not if they had a fixed outside structure. And so, that was something that they realized didn't make any sense from a health perspective, and so they allowed that to go forward. But that's how they're making decisions right now. And unfortunately, immunity doesn't really play into that. It doesn't fit with their goal of trying to keep, everybody. They don't have the resources to make sure that everybody is following by the rules, so they have to rely to some extent on individual responsibility. The legislature is all over the place on the issue of immunity. You hear from Republicans who are pushing very hard, very loud for general immunity. There's a couple of bills in. There's also been two Democratic state senators and one Democratic assembly person who've introduced broad immunity bills. We've been told they've been referred to the judiciary committees in both houses. I know at least in the Senate, the chair of the Senate Judiciary Committee has said in no uncertain terms that he was not interested in moving a broad immunity bill right now. He seems to think, he follows the thinking of the governor that these are really individual responsibility. If you're going to open, whether it's a pool or a restaurant or, a medical provider, you do have to take on the responsibility of making sure that it's safe in this environment.
And is the fear that if immunity is granted, that those people that are now immunized will not work as hard to protect the people that are going to be utilizing either their restaurant or their pool?
Yeah, that is exactly what the thinking is. They think that it is difficult. The rules you mentioned, somebody mentioned it before, the rules that they've put out, whether it's for pools or restaurants or whatever, are onerous. They're complicated. They're not necessarily easy to do. And, that is because this is a very difficult thing to manage. So no, they don't want to remove anything that may get in the way or, allow people to relax a little bit because they fear a relaxation.
George, if I could just add a comment to that, Matt made the point that the only thing that really will give associations comfort and will give their attorneys comfort to say, okay, it's a reasonable risk to take, is if the bill, at least as far as community associations go, are a broad bill. On the other hand, understandably, I know a lot of people don't want to hear that, but understandably, the state says, well, we have these policies to make sure we're keeping the COVID problem under control. And it does encourage a lack of care when you've got immunity. So we're trying to thread a very fine needle here in trying to, on the one hand, get immunity that's broad enough to satisfy our membership, while on the other hand, dealing with the fact that the state doesn't really want there to be broad immunity given. So it's not an easy task. And, you know, for those who are on this call today, it's highly unlikely that anything's going to happen for this summer. We're already thinking about the future. We're thinking about, geez, we don't know, even if there is a vaccine in early 2021, how long will it be before enough is produced? How long will it be before enough people have it, you know, et cetera, et cetera, et cetera. We may still be facing this issue next spring and summer. So, you know, our target is, frankly, from a timing point of view, it's not likely to happen this summer.
Thanks for that, David. Actually, a question came in, and this is a good time for me to remind everyone on the call that please use the chat function to ask your questions and not the question function, because I'm not able to see what those questions are unless Jackie feeds them through my email. But one of the questions that we just got, Michelle, and I'll address this to you, and I know you don't have a crystal ball, but I'll ask it anyway. What's the time to get any of these bills passed? I think that, as you say, they all seem to now be funneled into the Judiciary Committee. And I suppose that if there's anyone interested in that committee, they're going to have to start kind of categorizing them, because there's some that only apply to schools, and there's some that only apply to businesses, and to some to nonprofits. And if we were to join the fray and ask for a bill that only applies to common interest communities, that's a good thing because it gets us a seat at the table. But how do you see that playing out, and to finally get some kind of a consensus among the legislators to get it passed, to get it to the governor, and to get it signed? Is there any reasonable prospect of that happening, you know, in the next couple of months?
In the next couple of months, that gives me a lot of wiggle room. In the next couple of weeks, probably not. I mean, and let me give you a little background on what the legislature is doing now. They moved the fiscal year to October 1. It used to be July 1. So in the weeks leading up to July 1, you would have this fury of negotiations all around the state budget. So now the governor has to give a new budget address. It's August 20 something, second or third week of August. He gives a new budget address, and then they go into, what would typically happen in June, which is this flurry of negotiations around the state budget. And that's happening end of August into September. So quite frankly, I think given the circumstances of where New Jersey sits in comparison to other states, people in the legislature are sitting back and saying, well, I think we're doing something right. And let's just take a deep breath. The state budget, in an understated way, is a disaster. It's really a mess in a way that they have not ever seen, certainly not in a very long time. So a lot of energy is going to be spent in the next couple of weeks on the budget. I think that once, and we don't know, this is going to really be determined by what happens with the virus in New Jersey. If we start to see spikes again, I think your chances of having an immunity bill become much more difficult. I think if we continue in this sort of leveled off place that we are right now, I think that it is entirely possible that you could start to have conversations about this, probably, towards the end of the budget or after the budget gets passed, which would be October. And I think, George, you asked me this question before. I'm not quite sure I got to it, but the difference between a broad immunity bill, are we better served seeking amendments to that, or trying to have our own very specific bill drafted? And quite frankly, I don't think it's either or. I think you probably have to be prepared to do both. In this kind of environment, everyone who's trying to open something is talking to their legislature about the issues that we're having, and a lot of them have brought immunity to the table. It's higher ed. The list was posted before. Higher ed, schools are, I mentioned before the budget, schools are a huge issue, and the legislature is going to be involved with oversight and stuff about that for the next couple weeks. And immunity gets brought into that conversation a little bit. It's going to come up in a variety of ways. By having our own specifically tailored bill that gets us a seat at the table, it kind of puts a placeholder out there to talk about these issues, you know, saying, hey, we're another place that's having a problem. But you don't know how it's going to really play out at the end. They all might get negotiated into a larger bill. Or at some point, if we continue to have good results and the virus load stays low in New Jersey, maybe they'll do a broad immunity bill, but you want to make sure that your amendments are in and it works for you.
Well, and thanks for that. And with your help, we have, those of us on the LAC have really established some very strong relationships with some key legislators. And I think I speak for all of us on the panel when I say to everybody who's attending the call that we will be reaching out to you when it's time for us to call on you to support our efforts in pushing these bills that we ultimately fall in behind by reaching out to your legislators, whether it's our own individual bill or whether it's an amended bill that's already in existence. We're going to be following all of those things very closely. We're going to be moving as quickly as we can. And when it's time, when we've been told by our contacts what the most effective way to proceed is, and when we start to hear what's coming out of the Judiciary Committee and what the chances of any particular bill moving, we're going to be reaching out to all of you and asking for your help to reach out to your individual legislators to tell your own story that I live in a common interest community and this is important to me. And it's important for my vote. So that's, and you've been very helpful to us in the past when it comes to those types of legislative efforts. And we're going to be calling on you again. It's not going to be tomorrow, but it'll be soon, as soon as we were able to, based upon all of the data and information that we accumulate, when we decide what the best approach is, we're going to be there asking for your help. So I'm going to jump down now, and Michelle, we'll come back to you in a minute to talk more about the bills themselves. But Vinny, can you give us a little bit of your take on what you know from the insurance perspective and why this has become such a difficult issue to address?
Sure. So thank you. You know, I kind of feel like the ex-husband that shows up to the spouse's family dinner. Nobody wants to see me, and they certainly don't want to hear what I have to say. But having said that, let's see if I can share my screen here. Can you see my screen? No.
Good.
Yes.
Yes.
Okay. So I want to talk about just the two problematic exclusions that you're going to see, both from the directors and officers perspective and most likely the general liability perspective. Many of you probably have seen this language somewhere. All of the D&O policies have a very similar verbiage, which basically states, you know, we're all a part of such claim or suit is directly or indirectly based, attributed to, caused by, arising out of, anything that basically has anything to do with bodily injury or property damage would be excluded from the directors and officers liability. So most of this is designed because of the BI, the bodily injury claims would fall to the general liability policy, and that would get picked up under the general liability policy. The problem you have is some of the decisions that you make or are not making can be called into a suit under a directors and officers suit. They didn't like that you didn't open up the pool, or that you did open up the pool and move forward with the pool. Those claims would also not be covered and would not have a defense under the directors and officers liability. We kind of use that but-for language. But for COVID-19, would these claims have been brought against the board of directors? And if the answer in any way, shape, or form is yes or no, then there's not going to be any defense coverage under the D&O policy. Where you have a little bit of a problem, you know, some of the liability policies currently have an exclusion for virus, bacteria. Some have pandemic. Most will see, if they haven't already on renewal, we'll see a specific communicable disease exclusion. But the problematic exclusion that we're seeing under the general liability is this one here, expected or intended injury. If you have a bodily injury that is expected or intended from a standpoint of the insured, this exclusion does not apply to BI and will not provide a defense for those types of claims. So most people are expecting when they open up their pools that somebody's going to catch COVID and they're going to have to address it and deal with it. And as a result of that, this could be the problematic language within the general liability policy that would exclude coverage. If you can get past the other exclusions on the policy for virus and bacteria and communicable disease, this would be the last kind of stance that they may take. Now, if you get a claim, you certainly should put that claim through and let the carriers ultimately decide that they're going to deny it or provide that defense. You certainly will get a reservation of rights letter outlining all the different exclusions that could be applicable. So we don't know specifically or 100% for sure that they'll be 100% denied, but those are the languages that we have seen or have heard that carriers are going to use in denying this type of coverage. And I guess the bigger question.
For a second. One of the questions that just came through was, and you mentioned pools quite a bit, and I know a number of us have mentioned pools. Mm-hmm. I think I know the answer to this, but I'll throw it out to the group. The question is there a greater risk of transmission of the disease and therefore filing of a lawsuit with regard to the opening of a pool as opposed to other amenities? At least from your experience, what are you hearing?
Well, so from what we're seeing and what we're hearing from all the CDC and the guidelines is outdoor activities have less of a higher transmission rate. Doesn't mean that you can't still get it as a high exposure where somebody's talking or yelling or even singing has the ability to spread the disease very quickly. But if you're outside, it's less of a risk, but there's still a risk that exists. They still don't know enough about the disease and how it's being spread. There's too many of the people have no symptoms or asymptomatic, and you wouldn't know that having a conversation with somebody next to them. Indoor activity is more problematic. So anything within the clubhouse is going to be a problem because you have ventilation, you have circulation, and that's where they're seeing there's more and more exposure over time of the air being recirculated that you're going to have a higher risk of getting exposure. So I don't know if that answers your question.
Yeah, it did. David, what are your thoughts on that?
Well, George, I wanted to turn the table back to you on something, because you let us all know that you had heard about swim clubs in South Jersey, or at least one swim club who opened and then something happened. So can you just talk about that for a minute?
I'd be happy to. Actually, my experience has been that the majority of the associations that I represent, their boards have decided not to open their pools, but there have been a couple of HOA pools that have opened down here. And one of the reasons that was that they were getting a lot of pressure from their residents saying, well, the local swim club is open, why can't we be open? And interestingly, with regard to those local private swim clubs, remember, they're not nonprofits like we are, but they did open. And then, of course, I saw some news reports last week that there's actually 2 of these private swim clubs in the area where positive COVID-19 diagnoses had been made, and as a result, they had to shut down again. So yes, that's happening, and that of course could happen with our HOAs that open their pools as well. Is that the moment that there is a diagnosis, then you're going to have to go through the whole investigative process of contact tracing, find out who was there and when, and who were they in contact with, and there's nothing easy about this analysis whatsoever.
And it's hard to determine, where they work. It takes 2 weeks for it to develop. You don't know specifically where you're going to catch it, and then you have to go back 2 weeks and notify all those people. It's when opening, even down, I'm in Long Beach Island this week, the restaurants are opening and closing as they get a positive, somebody tests positive or a customer comes in that's positive, they shut everything down for 2 days and clean it and do a thorough thing. So I don't think there's anything that's going to remain open steadily without having to have some issue.
Yeah.
And I think your story,
go ahead, David.
I think your story, George, goes to the issue, and I think we hear this from a lot of owners and a lot of associations who have not opened their pool. Oh, no one will ever be able to prove where they got it. The fact of the matter is, under the Department of Health requirements, every person has to sign in. That's so that contact tracing can be done. And if in fact somebody tests positive, they're going to look at everybody they were in contact with. And if they find there was somebody else at the pool during the time when they could have gotten the infection who was also positive, it's not impossible to demonstrate reasonably. Again, it's a preponderance of the evidence standard. It's not a beyond reasonable doubt standard. So in a civil case, somebody may be able to establish that by the preponderance of the evidence, that's the only logical place they could have gotten the disease. And that's the problem.
Yep. Right. As I expected, we've blown through 50 minutes already of our hour, and we still have stuff to talk about. So I wanted to remind the listeners that David and I are going to review a couple of quick updates at the end before we sign off about the Radburn regulations and our request for a stay. And David's going to talk a little bit about the new regs on adequate reserves. And also I'm going to touch briefly on the status of the debt collection prohibition bills. But Paul, we just talked a lot about the decisions that board members have had to make this year, and you've been in that seat, and you're going to be talking directly to a bunch of folks on this call who are having to make those kinds of decisions. What can you tell us?
See if I'm unmuted. Good. Well, yeah, I think I want to talk to the group of people who are board members or residents of common interest communities to remind everybody else that this group is a lot of people, and it's going to be very important when we do legislation. But what the board members and residents went through is remarkable this year. The CAI survey that many of you probably saw said that this year 80% of New Jersey's pools did not open. And how can that be? Because on November 8th, the governor issued a tweet that said pools will be able to reopen on June 22nd. And what we heard from that depends on where you are. If you're a resident of a common interest community, you thought terrific, wonderful. Where we be able to have the grandkids, because all they heard was the word reopen, will reopen. Board members heard the word may reopen, so they were concerned, and because what does may mean? And the professionals, like the 6 folks on the screen with me, all they heard was big problems. But the boards were optimistic. They felt that when the Board of Health standards were out, well, this is just going to be a pain in the neck. We got to hire a social distance ambassador and spend a lot of money. And then they started hearing about the cost and timing would have been fine. But then they heard from the professionals in the insurance and the legal profession and property managers that we have this other problem here. So their confidence that they will be open by the 4th of July, at least for board members, they had to start sending out notices. We're going to be delayed. We may not be open because of blah, blah, blah. And residents were really angry. So the board members worked their tails off, making decisions. Virtually all of them wanted to open their facility, the pool, particularly if they could. But they by June 20th, the 80% decided to stay closed. And the CIA survey says that fear of exposure to legal liability was 84% of the reason, and lack of insurance coverage was 74% of the reason. The HOA presidents and board members I talked to said it was a no-brainer to not open. But right now, boards are extremely concerned this will continue for the foreseeable future. And this will mean that if it continues on, you're going to lose a lot of board members who are going to say it's just not worth it, especially that what Vinny just said, the personal liability for lawsuits that will be uninsured. So this is a problem that's got to be solved, and that's why this discussion is so important, and that's why I'm happy that I'm on the LAC, and we're working very hard to come up with a solution so that next year is not like this year.
Yeah, thanks, Paul. Listen, I know a lot of board members out there listening are probably saying to themselves, I didn't sign up for this. We're talking life and death type situations and decisions to be made. And we very much appreciate the effort and the time and really the good faith that they put into their decisions. Vinny, by the way, we just got a question in about insurance coverage. Talk to us about what happens if the board decides not to open their amenity and they get sued for that. Are they covered?
Unfortunately not. As I said, that exclusion, that but for, right? But for COVID-19, you would not have made that decision not to open. So the exclusionary language that I showed, anything attributable to bodily injury or property damage, even decisions arising out of it, would not be covered or defended.
But I will say that attorneys will take a different approach on that. I mean, we think that's baloney. That is a dodge by the D&O carriers. That is not a claim for personal injury or related to personal injury. That is a claim for a wrongful decision. What is a claimed wrongful decision to not open the pool? And I will tell you that I think there would be a very good chance on a declaratory judgment action for the insurance company to get held in. Of course, declaratory judgment actions are not inexpensive. And if the insurance company puts us in that position, you're going to spend a lot of money just getting the carrier to cover. So none of this is good news, obviously.
Yeah,
but,
but if the claim comes in, I said, put the claim in and let the carrier make that determination. I can tell you, certain carriers have already said that that's going to be their defense, and other ones are saying submit it and let us review it, and we'll go from there. From what I'm hearing, I'm not an insurance company. I'm just passing along what they're saying is they don't think it will be covered.
Hey, Vinny, if an immunity bill is passed that does apply to common interest communities and their vendors, would that in any way affect the insurability of these associations?
No, it's not going to change the exclusionary language already there or coming with the communicable disease exclusions being put on the policies at renewal. So, it's just going to hopefully give the board members a little bit more confidence in continuing to stay as a board member and make those decisions that they have some immunity, and that, as Matt said earlier, the likelihood of a claim coming will be somewhat diminished. But somebody can always sue, and we still have to defend it.
Ed, what are you seeing with your clients? Are most of them keeping their amenities closed, and are they reaching out and asking for immunity in these types of situations?
Well, I think all of our pools closed. 28 pools closed for the season. Our other amenities, our indoor amenities, are closed. There's a lot of noise about that. They actually haven't been asking us about immunity, but the fact that I'm talking with them now about immunity, they're getting interested in, and I do think they think there's some help and relief through immunity. But the vast majority, if not all of them, really, I guess, on all their indoor amenities, they're closed. Yeah.
Michelle, okay, so here we are at the 1 o'clock hour, and we are going to go over a little bit, and I'm going to ask the 200 or so folks that are still on the call to hang in there, because I'm going to give you, David and I are going to give a quick update on some of those other issues. But Michelle, just over the next couple of weeks, what I see happening is that we're going to be looking to reach out to the sponsors of the age-restricted bill to see if they'd be amenable to us making or asking them to make some of those revisions that would be a little bit more inclusive, not just age-restricted communities, but all common interest communities, right? And then also, based on what Matt said, that he thought the Utah language was the Utah bill language was good for us, and that perhaps we could craft a bill that we could then ask a sponsor. Is that something that you can see us getting accomplished in the next couple of weeks, while I know that the legislator is going to be talking about something else?
Sure. Yeah, introducing bills and having bills move are really two different parts of the process. So certainly, yeah, we can have conversations with legislators. I know, as somebody mentioned before, you've all developed some really good relationships, and just sitting down with them to explain what the situations are. We can do that now. And if we have language to give them, start getting the bills drafted, and yeah, it takes probably a couple of weeks to educate and have a bill be drafted and then introduced. So now's a good time to do that.
Yep, and that's what we're going to do. David and Matt, a couple of questions have come in with regard to assumption of the risk and what about waivers? What if our people sign waivers before they come in? Does that protect us? David, I'll go to you first, and then Matt, I'll let you clean up what David says.
The problem with waivers, and it's better to have them than not to have them. So if you were even, we've got communities that are opening tennis courts, pickleball courts. I mean, we've seen that. And the question arises, well, should we get a waiver? And the answer is absolutely, you should get a waiver. And it should be a carefully crafted waiver that explains the risks being undertaken, the fact that the person is assuming the risk, that they understand what that means, that it is absolutely unambiguous. The problem is, though, that the courts don't like to enforce waivers, and they will look for every reason imaginable to not enforce waivers. So I will just say that, yes, get them. They may be helpful, but don't rely on them. Matt?
And Matt, if one of our associations puts up a big sign at the entrance to the pool saying, enter at your own risk, it's all on you if you get sick, is that going to work?
Absolutely, 100%. No, the sign is not going to help. And to go on to David's point, there's case law that says a waiver executed by a guardian for a child, someone under 18, is not enforceable. There's case law stating that a waiver would not be enforceable if there was a violation of a statutory duty that existed independent of the waiver. And there's no case law saying that a waiver that a condominium forces its owners to sign to use a common element is enforceable anyways. And there may be arguments against that. So, again, I totally agree with Dave. If you're gonna open your amenities, have a waiver. Your attorney has to write it because there's a bunch of magic words that need to go in it. There's a bunch of cases that say, well, if you don't say you're waiving your right to a jury trial, then it's too confusing. So, you have to have all the right language in there, and it has to be carefully reviewed.
Great, thanks. Angela, I don't know if you can hear me, if you're still on, but I know that a couple of our presenters today had PowerPoints and screen information for us. Are the folks that are on the call able to access that information? Are you able to send that to them? I don't know if you can jump.
Yeah, I am on. Can you hear me?
Yes, I can hear you.
So if they're, just email either myself or Jackie if anyone wants that PowerPoint. Are you willing to share that, right, George?
Absolutely. Right, Matt?
Okay, yes, we'll get it to them.
Okay, great. Okay, I'm going to move on real quickly to just a couple of updates on some important things. One is the Radburn regulations, as you probably all know from the member or the client alerts that you got, that the appeal of the Radburn regulations has in fact been filed, and it's winding its way through the process at the appellate division. We have informally requested of the DCA a stay of the effective date, which, as you probably know, was May 18th. We're seeking a stay of that to allow the appeal to work its course. It would be our hope that we'll be able to resolve all of these issues without having to go to the full end of the litigation process. But in the meantime, what's important for all of you, especially managers and board members who are out there trying to understand whether or not you have to follow these Radburn regulations in your upcoming elections this fall, the answer is we had hoped to have known by now that the stay would have been granted. We have been given some reasonable assurances that it looks like that's the direction we're heading in, but we haven't officially gotten it. We're not going to wait forever. We need to know soon whether or not there's going to be a stay, and if we don't get it informally, we're going to officially have to file for the stay, and that's an official motion, and we'll keep you posted on that. The debt collection bills I wanted to briefly touch on, because before the whole pool issue came up, what we were most concerned about was both a federal push as well as a state push for bills that would have prevented us or substantially prevented us as associations from collecting overdue assessments and related charges during the pendency, and then for several weeks, if not months, after the pendency of the emergency. In particular, we were looking and concerned about S-2330, and that was the Senate bill. And unfortunately, that bill would have prevented us from doing anything from writing a collection letter to filing a lawsuit to filing a lien. And we were very active in our communication with the sponsors, and fortunately they heard us and they deleted almost all of the bad provisions of that bill before it was passed by the Senate. It has now been sent over to the Assembly, and that is the counterpart is A3908, and that is still in the Assembly. And Michelle, the last time I checked, it did not look like it was moving anywhere.
No, the consumer advocates who had pushed for the bill in the first place were very unhappy that a lot of the things they had asked for had come out of the bill. So now there's really nobody pushing it at this point in time. Although that might change, particularly when the time limit on eviction starts to run out and other consumer protections that were in place meet their deadlines. You might see another push for it, but the bill as it stands today is good.
Okay, good. And I can thank all the folks listening and many others who wrote to their legislators at our request to put the pressure on them to say this would be bad for us, and who the 1.5 million of us who live in common interest communities in New Jersey. So we're very pleased about that. And then there was another bill, S-2423, which was passed in the Senate. It was labeled as a bankruptcy bill, but really, in effect, what it did was it made it more difficult for associations to collect the monies that are owed to them by those folks who filed for bankruptcy protection. It passed in the Senate. We have been in contact with the Senate sponsor. We were not successful in getting the language taken out that we wanted taken out, but the good news is that it has not found the sponsor in the Assembly yet, and therefore it's not very close right now to being law, and we're going to keep monitoring that. Correct, Michelle?
That's right.
Okay. All right, David, can you give us 30 seconds or so on the new regs that came out about adequate reserves and benefits derived?
Sure, and this is going to mostly apply, in fact, entirely apply to newer communities. It doesn't apply to people who, have more mature communities that are long out of developer control. But for years and years and years, 30 plus years, managers, attorneys, accountants have dealt with a transition issue known as benefit derived. And it has been this amorphous concept that developers must contribute to the association while they control the association an amount of money equal to the benefit they derive from the money spent by the association. It was undefinable, it was debatable, it ended up causing endless problems, both on the developer side and the association side, quite frankly. The developers came to us about 2 years ago and said, we want to make some changes on the reserve regulations, what exactly has to be reserved for, how long a period of time do we have to go out before we don't have to reserve for something, et cetera. And we said, fine, we're happy to sit down and work that out with you as long as you work out this benefit derived. The short story is, after many meetings, we came up with a joint proposal. We took it to DCA, and to DCA's credit, they basically published rules that were almost wholesale what we asked for. That is now in the public comment period. The public comment period ends mid-August. I don't expect that there's going to be much public comment on those bills, and hopefully that will lead to a rapid final publication of those rules, which is going to be a real benefit to everybody involved in defining what the obligations of a developer are.
Great. Thank you so much, David. Folks, I just got a question about the Radburn appeal, and the question is, were all of the new Radburn regulations appealed or only some of them? So David, correct me if I'm wrong here. While we certainly objected to most of them, we didn't object to all of them, but the nature of the appeal is such that we are asking to appeal the entire package of regulations, and the stay will apply to the entire package of regulations. And then we're ultimately going to work on each one individually to see which ones survive the appeal process, correct?
I mean, one of the pieces of leverage we have with the DCA is one of our arguments is they had no authority to actually adopt any of these regulations. So if they want to save some regulations that we find acceptable and modify others so that they would be acceptable, it might be to their benefit to do so, because if they don't, it's possible. We're certainly not saying it's a foregone conclusion, but it's possible the appellate division could find that they did not have the power to adopt any of those rules.
Great, got it. Anybody want to give some closing thoughts? We're already 12 minutes over, but it was all important stuff. I want to thank every one of my panel members, and Angela for arranging, and Jackie for arranging this for us. And thanks to all of you who are out there listening. Please stay tuned. We'll probably, as a LAC, present another virtual update in a month or so. You can always check in on the CAI New Jersey webpage for the latest information. And if we need to get another message out to you on a quick turnaround, we'll do that by way of our email blasts. But again, thank you all. Good luck, stay safe, and stay in tune. We're going to need you, so be there for us. Thank you so much.
Bye.
Okay, Angela, you can shut it down.
Thank you, everyone. And just a quick reminder, the recording will be on our website if anyone would like to reference it as well. And thank you all you speakers. Thank you so much.
Thanks, everybody.
Bye-bye.